Good morning. I'm Arthur Seymour Jr. I'm here on behalf of the Knoxville Bar Legal History Project. Today, which is July 24, 2014, a Thursday morning in our offices at Francis McCollin Seymour, I will be interviewing Judge Wheeler Rosenbalm about his long legal career and other interesting aspects of his life. Well, Judge Rosenbalm, or Wheeler, I may call you, during the interview, thank you for joining us today. I would like for you to tell us about your experience growing up in Anderson County as a young man, as far back as your memory can go.
On November the 24th, 1937, and my family lived on a farm, and we continued to live a farm life for all of my early years. I went to a three-room elementary school named Mountain View Elementary School. They say that school is no longer there, but that was the beginning of my formal education, and interestingly enough, the teacher that I had in the first grade, Mrs. Laura Hutchison, lived there in the community, and she was zealous of the upbringing and the education of all the youngsters in the neighborhood. And she decided at the end of my first year in school that I was a little bit young and immature to be passed on to the second grade, so she held me back in the first grade. I sometimes jokingly say probably it's notable in my life that I flunked the first grade. That probably gave me an incentive to work a lot harder in school. But in any event, I finished up my elementary education there at Mountain View in 1952, and I went to Clinton High School and graduated at Clinton in 1956. During all those years, as I indicated, my family owned and operated a farm, and we principally did dairying, had a dairy farm, but also grew tobacco and some other crops. And so I lived, I guess, what was a pretty normal farm life for a youngster. I had to work in the fields and on the farm, and actually enjoyed that for the most part. And of course, it gave me an opportunity to pursue developing pastimes, hunting and fishing, which I enjoyed for many years after I grew up and was at the bar. So I'm sort of a product of the rural Anderson County life, and it was a great time, and I remember those years very fondly.
You were talking about the enjoyment, and I'm sure the hard work growing up on a farm in rural Anderson County in the late 40s and early 50s were like, and hunting and fishing. What else did you learn out there that served you well later in life?
Well, I certainly learned that hard work is one of the keys to success, and out of all of that, I certainly learned that I didn't want to be a farmer for all of my life or pursue some other careers of like nature, and I suppose that the hard work that I endured there was one of the great incentives for me to go ahead and get as much education as possible and later on pursue a profession. But farm life is a disciplinary effect. I think it convinces you that you need to be prepared every day, and you need to do what needs to be done every day. You can't put it off for a later day.
Has to be done every day.
That's right. As the saying on the farm is commonly that you have to make hay while the sun shines. So I learned a lot. It was a great disciplinary tool in my life to have grown up on the farm.
And I assume you helped your parents in all the work that went on.
Everything. I remember fairly early on in my life, my father obtained a tractor. Before that, the work in the fields had been done with mules and horses. And after my father acquired that tractor, my dad told me on one occasion to go out and plow the garden and turn the garden, get it prepared for use and seeding. And my grandfather, who lived nearby, urged me to do that with a mule. And I said, well, we don't need to do that with a mule. We have tractors down. He said, well, you never know when you might have to rely on the mule. So I did all of the farm chores that are typical of that kind of life in rural East Tennessee.
Clinton High School, when you attended, was right downtown in Clinton, behind the present courthouse, wasn't it?
It was. It was located 2 blocks from the where the present courthouse is located. Of course, the present courthouse building had not been built at that time. And as a matter of fact, one of the interesting things that I experienced in my high school life is I ran for and was successful in becoming elected as the president of the student council during my senior year. And we held that election with the help of the election commission. We held that election in the courthouse and used the equipment, the machines and so forth that the election commission then used and maintained. And it was a very interesting experience to start me on adult life, particularly one that later on involved some very important elections.
That that was the old courthouse in
That was
Clinton,
the old courthouse
that
building.
burned
Yes.
in the late 50s, early 60s.
Early 60s, right.
Yeah. When you graduated from high school, had you made any decisions about your life after that, further education?
Not a lot, but had begun to develop some tendencies. Interestingly enough, although I wasn't interested in farming, I took the vocational agriculture courses that were offered at the Clinton High School. And Mr. L.M. McElwain, the vocational ag teacher, was very encouraging for me. And I think he recognized that I wasn't going to be a farmer, but maybe there were better things for me to do in life. And he encouraged me to become involved, among other things, in a public speaking contest that the FFA, Future Farmers of America, engaged in every year. And as a matter of fact, I won the East Tennessee trophy for that speech contest and was able to go on to the statewide contest in Nashville and placed 3rd there. And so at a fairly early age, I began to develop interest in public speaking and in things that would sort of point toward a later career in the law, although I didn't have any real strong feelings about what I was going to do. And when I graduated from high school in 1956, of course, I didn't have any money to go to college, but Coach Martin Peters, who was the basketball coach at Clinton, had decided that he was going to give up coaching and go to Lincoln Memorial University as the alumni secretary, and he urged me to go with him, as he was given to say, to LMU. And he said if I would go to LMU, he would help me obtain a scholarship, and he would help me obtain a campus job where I could earn some money to defer school expenses. And he did all of that. And so when I went to LMU, I wasn't certain what I would like to do, but I knew that I had some interest in business and that kind of career. And so I majored there at LMU, had a double major in accounting and economics and a double minor in business administration and English. And while I was there at LMU, I was successful in obtaining a scholarship during my last 2 years with the Kemper Foundation, a foundation established by the James S. Kemper Insurance Companies in Chicago. And they offered the recipients of their scholarships a summer job at one of their locations, and I spent 3 summers out in Fulton, Illinois, working in a life insurance company. And I became acquainted with the lawyer who represented that life insurance company, which was named Fidelity Life Association. And so he told me about a lot of things that he felt I should do to equip myself to go to law school, and he encouraged me to go to law school. And so when I had graduated at LMU in 1960, I decided that I should pursue a legal career and began to make arrangements to go to law school. Interestingly enough, there were no strings attached to the scholarships that Kemper had provided to me before I graduated from college, but they said that they would be willing to finance my law school career, provided I made a commitment to return to work for them for some, at that time, unspecified period of time. And initially I intended to do that, and I enrolled in the Cumberland Law School in Lebanon, Tennessee, and shortly after doing that, I discovered that Cumberland probably was not going to remain in Lebanon, and so I thought I should go to a law school in the state of Tennessee, and I withdrew and came to UT, and the Dean Warner, Harold Warner, encouraged me to just go ahead and make the transition at that time. But I felt like I had lost sufficient time in the first quarter of law school so that I should wait and start the following year. And so, excuse me, I decided that I would do that. At that time, the draft board had told me if I didn't remain in school, I would be drafted. And so in order to fulfill my military commitment, I went ahead at that time and joined the Army Reserve in a program that required 6 months active duty training and 6 years service. So I joined the 489th Civil Affairs Company in Knoxville and went on active duty for 6 months. And then when I came back the following fall, I went into law school at the University of Tennessee. So
what year did you enter there?
I entered in 1961. I was in the fall class of 1961.
And did you go straight through law school, or?
No, I did attend summer school one summer, and then one summer I did not go to school, so took sort of a break in the summer between my second and third year of law college. And during that period of time, I worked in a Western Auto store, selling bicycles and car tires and all sorts of things.
You might tell us about some of the faculty members. You and I overlapped a little bit, and there were certainly some colorful and interesting people teaching at the law school.
Yeah, you know, the faculty, I think, at the time that I was in law school was quite unique, and it did have some very colorful people. Dean Harold Warner, whom we all referred to affectionately as Colonel Warner, because he had spent considerable time in the Air Force Reserve, and I think his highest rank attained was Colonel when he retired. But we referred to him as Colonel Warner. And Colonel Warner taught all of the real property courses at that time, and he was an extremely engaging and entertaining professor, and he would hypothesize situations and call upon students, and he oftentimes associated the student with something in their background prior to law school. For example, he referred to my good friend Harvey Cameron, who was from the Chattanooga area and who had been through the Naval Academy. He always referred to Harvey Cameron as Admiral. And so Colonel Warner had a great capacity to make what could have been, I suppose, a dull course of study a very interesting one. Dr. Elvin Overton was likewise very colorful, and he would get into great animation and active discussions with students about hypotheses that he had produced for the class to consider. And he was sometimes would jump up on the table that he used as his lectern and raise his voice and animate with his hands, and he was just an extremely engaging personality. And there were others that perhaps were less engaging, but nevertheless were interesting and very capable and encouraging professors. My law school experience was one of the highlights of my life. I loved the study of law and enjoyed my years as a law student at UT eventually.
Good. What year did you graduate?
1964. Because I'd gone to school in one quarter in the summertime, I was eligible to graduate in March of 1964. But in the meantime, a number of students were searching for jobs and talking about employment upon graduation and that sort of thing. And somebody asked me what I intended to do and upon graduation. I really wasn't sure, and I knew I loved the study of law, and I had started giving some thought to teaching and going on and getting an advanced degree in law and teaching at some law college. And I'd mentioned this to some of the other students, and they had mentioned that to Dr. Lacey in one of those coffee drinking sessions that students and law professors often had at the old Ellis and Ernest drugstore,
which was right across from the law school.
Right across the street from the law school. When you studied so much in the afternoon that you got a little bit sleepy, then you took a break and walked across Cumberland Avenue to Ellis and Ernest drugstore, and often drank coffee with law professors who were likewise taking a break there. And so Dr. Lacey had learned that I had some interest in teaching, and at that time, I did not know this, but Professor John Ball, who was a professor at the law college and also then general counsel for the University of Tennessee, and who taught all of the Tennessee procedure courses given at the law college at that time. John Ball, Professor Ball had informed Dean Warner that he didn't intend to continue teaching. Professor Ball had a son that was enrolled in law school and was reaching that level of study where he would be taking courses from Professor Ball, and Professor Ball just simply apparently didn't feel comfortable in teaching and grading his son's paper, and so he decided to retire from teaching. And Dean Warner, upon learning this, had been talking to Dr. Lacey and other staff members about a replacement for Professor Ball. And Dr. Lacey mentioned to Dean Warner that I had some interest in teaching. And so Dean Warner came to me and asked me if I would be interested in taking the job that Professor Ball was doing. And of course, I was delighted and almost beyond belief, really. I was surprised that he would offer a teaching job to someone right out of law school. But anyway, I indicated I was interested, and so I accepted his offer to teach. And since I had a quarter of time on my hands, I was not to start until I'd taken the bar in the summer of 1964. And so I decided that I'd just go to law school an extra quarter, take some courses that I had not been able to take beforehand. And so I continued for a 10th quarter and actually graduated in June of 1964.
And when did you start teaching at the law college?
Immediately in the summer session in 1964. I was in June of 1964. I started teaching at the law college, and I started taking the review course to take the bar exam that following July, and so I really had my hands full in the summer of 1964. I was teaching and studying for the bar exam, and it was a busy time.
The law college is on semesters now, but at that time, the school year was divided into what we called four quarters.
Yes.
And you could go year round.
Yes, right.
And the bar exam at that time did not have a multi-state component, did it?
No, it was 2 days of essay type questions and very comprehensive coverage of the law in Tennessee.
What courses did you teach when you?
Well, I taught all of the procedure courses at that time. This was in the days before we had the civil rules of procedure, so in Tennessee, our procedural system for the operation of the courts was made up of some legislation, some statutes, but much of it was derived from the case law. And we had a different system, somewhat different, for the circuit court and for the chancery court. The pleadings bore different names, and there were different rules about when they should be filed and what they should contain. And so we had a system for the circuit court and a different system for the chancery court. And then, of course, we had to have some instruction about appellate procedure, and that was before the days of the rules of appellate procedure. So I taught a course that we called Tennessee Law Procedure that equipped students to handle cases in the circuit court. And our chief instruction manual for that was a book called History of a Lawsuit, written by Judge Gilreath over in Lebanon, Wilson County, Tennessee. And in Chancery Court, we had a course of study called Tennessee Equity Practice, or Tennessee Equity Procedure, Practice and Procedure. And our chief study manual, so to speak, for that was the 2-volume work written by Judge Gibson called Gibson Suits in Chancery. And so I taught the law procedure and the chancery procedure, and then an extensive course, 5-hour course for trial and appellate practice. And that course sort of filled in the gaps that weren't covered by the courses in law procedure and chancery procedure, and also covered the practice and procedure for appeals to the Intermediate Court of Appeals and the Supreme Court. And in addition to that, I taught a course that we commonly referred to as Introduction to Law. It was a beginning students course to sort of get them acquainted with just the legal system, judicial administration in general. And finally, we did have the federal rules of civil procedure at that time, and I taught a 1-hour course in federal civil practice and procedure. Mm-hmm. So I taught all the procedural courses, and that covered a lot of ground. Today, of course, I think all that's covered in one course.
Yes, with the combined rules that we have. How long did you teach at the law college?
I taught there 2 years. After I had taught about a year, I began to get called upon by lawyers from all over the state to help them with procedural issues and problems and some other issues, but they would call me and inquire, and on numerous occasions wanted to employ me to help them with some brief or preparation for some procedural legal issue. And I took on some of those projects, and I always felt a little bit inadequate. I felt like I was trying to teach practice and procedure that I'd never engaged in myself. I had never had to deal with these things in a real-life situation. And I began to have some ambivalent feelings about whether I should remain in teaching. I thought that if someone remained in teaching those courses, perhaps they ought to get some practical experience so that they could speak from some first-hand knowledge about some of these problems. And I suppose that after working on some of these problems for lawyers at various places in our state, I began to realize that, this was something I could do, and I might enjoy doing it. So I decided that I would give up teaching at the end of the second year and go into private practice with someone. And so at the end of the second year, I left the law college and went with Francis McConnell and Seymour and began the private practice of law.
How did you decide on Francis McConnell and Seymour?
Well, that's very interesting. When I finally decided and got up the courage to go tell Dean Warner that I thought I would give up teaching and at least practice for a period of time. One of my notions was that I might practice for a while and then go to graduate school and then return to teaching. But in any event, I mustered up the courage to go tell Dean Warner that I had decided that I was going to leave teaching and would go into private practice. And surprisingly enough, he said to me in that very conversation two things that I'll never forget. One of them, he says, this is quite understandable. He said, you're just like a young airline pilot or airplane pilot. He said, you've been taught how to fly and now you want to fly. And he said, I also know the very place for you. I have a place in mind where I think you would enjoy practicing. And he said, they are looking for someone to take on as an associate. And he said, it's Francis McConnell and Seymour. And as I sat there in his office, he said, would you like me to call Arthur Seymour Sr. and make an appointment for you to interview with them? And I said, yes, I would. And of course, he did that, and I went to shortly thereafter to an interview with your father, and of course met a number of other people at Francis McConnell. And the upshot of all that is that I began active practice there somewhere around the 1st of September 1966.
At that time, the administrative level at the law school was fairly thin. I recall Dean Warner being a one-man placement office.
Yes, he was. And luckily for me and the law school, I suppose, is that when I told Dean Warner that I was interested in leaving and going into private practice, he had already heard from Don Payne, our dear and departed friend, and Don had expressed an interest in teaching, and Don was in the JAG Corps at that time, and Dean Warner said, will you stay with me long enough, even on a part-time basis, until Don Payne gets out of the JAG Corps and can come in and take over where you left off? And I said, Dean, I'll stay as long as you want me to stay, under whatever conditions. And so, but fortunately, Don was to complete his term of military service sometime in, I think, fairly early 1966. And so it was, I guess, a touch-and-go situation with Dean Warner. He was having to scramble to find somebody to keep the bases covered.
So you entered the full-time practice of law late in 1966.
Yes.
And where were the Francis McConnell and Seymour offices?
They were in the Valley Fidelity Bank building on Market Street in downtown Knoxville, and they had just recently, at that time, occupied those premises. That building had been recently developed, and Francis McConnell had gone in and had laid out a plan fitting for that firm, and it was nice offices and really efficiently arranged, and it was just a good office space. I was very much impressed with the structure of the office, and more impressed, I suppose, than anything else by the people there and the law library. I had not lost my interest in the academic side of the law, and they had a very, very well-equipped law library, and that appealed to me very much. And so I remember very much being impressed by the nature of their layout and the law library and the facilities.
Now, you remained in the private practice law for 24 years, I believe, 23
yes.
or 24 years.
Yes, until September the 1st, 1990.
You might tell us some of the matters you handled, the lawyers you worked with, and any good stories you have from those days.
That was also one of the highlights of my life, the time I spent there. I enjoyed those years tremendously. I approached the practice of law with much eagerness. I was excited about being able to go try cases, and so I started out being second chair to your father, Arthur Seymour Sr., and E. Bruce Foster Sr., and Fred H. Cagle Jr., and some other lawyers in the firm, but I worked with the three of them more than any other lawyers, perhaps, at the outset. And we tried a lot of very interesting cases. Mr. Foster took on a case to defend out in Scott County, Tennessee, a truck and car wreck case that injured a number of people. And I remember one of the highlights of that case is that he and I went out to try it, and Mr. Foster was a very interesting lawyer to try a case with. He didn't tell you beforehand that you were going to cross-examine a certain witness or be expected to put on proof by a certain witness. When it come time to do that, he'd nudge you with his elbow and says, "You take this one." And so it's great training. But in that case, Chitwood versus Myers, there were multiple claims on both sides. And although it had been done before, there was no real solid authority for submitting a pilot case to the jury and then letting the judge decide the rest of the cases based on what the jury decided in the pilot case. But the trial judge in that case decided, at our request and urging, that he would do that, and so we were successful in obtaining verdict and judgment in our driver's favor, and then from that the trial judge was able to dispose of the rest of the litigation. That issue went up on appeal and was affirmed by the appellate courts, and Chitwood versus Myers will always remain in my mind as one of those most interesting cases that I tried.
That would have been Judge Davis, wouldn't it?
Judge Davis didn't hear that case, but it was in that circuit. That's right. And I frankly can't recall the name of the judge that heard that case now. He was from Roane County. Willard Kittrell, it does come to mind. Judge Willard Kittrell tried that case. That was a serious but a fun case to try. We tried a lot of automobile liability cases and a lot of other litigation of all kinds. Your father and I tried a case, wrongful death case involving the Dempster Brothers plant where an electrician had got shocked in doing the work on the premises and had got killed. And very interesting and difficult case. Unfortunately, we did not prevail in that case, but it was the most interesting experience to try that case.
I remember a flood case you all had out in Anderson County.
Yes, well, it's actually in Campbell County.
Campbell County.
I actually tried a flood case in Campbell County that involved only property damages. Some loggers had been harvesting some timber in the headwaters of Coal Creek out there, and they, after they had left their work, came a huge downpour of rain, and the creeks rose up and washed away some very modest premises that belonged to one of the coal companies, but that were occupied by some residents that lived in that community. And so these residents hired who was a lawyer then, Lee Asbury, who later became a judge. They hired Lee Asbury and John McLeod out in Campbell County to represent them in property damage suits. And so By that time, the senior partners, Francis McConnell, had decided I could handle this litigation on my own, and they gave me the files and go out there and try this case. And so we went out and spent about 3 or 4 days trying this case to a jury, and prevailed. And it was probably my first introduction to trying cases with some of these country folks who spoke a little different language than the rest of us speak. But then in another flood case in Anderson County, the plaintiffs advanced a similar theory. Huge rain came there, and they claimed that the operators of strip mines had stripped the coal from the mountaintops in that region. Operators of those strip mines had left their strip pits open, and those strip pits had all simultaneously collected sufficient water to cause them to break open and flood Coal Creek, which comes down through Lake City, now called Rocky Top, Tennessee. And
formerly Coal Creek originally, wasn't it?
Yes, it was Coal Creek, exactly. And so it washed away a couple of young fellows who were trying to move a truck out of the path of the rising Coal Creek. And one of those escaped with his life. He lodged on a railroad overpass and was rescued, but the other drowned. And so my good friend, the late Robert Crosley, and Don Stansberry undertook to represent these folks and filed a wrongful death action to the man who for the man who had drowned, and they sued the owner of the property out there, which was the Coal Creek Mining Manufacturing Company, and they sued a bunch of strip mine operators, including my client, the Regal Corporation. And we spent a little better part of 2 weeks out there trying that case in the Anderson County Circuit Court. And Judge William I. Davis, a very fine trial judge, presided over that case. And at the end of the trial, the jury returned a verdict for the plaintiffs. We appealed that verdict, and it was set aside by the Court of Appeals, and that decision was affirmed by the Tennessee Supreme Court. The Tennessee Supreme Court actually just denied certiorari. They did not hear the case, but we prevailed on appeal. But one of the interesting things about that case was that, of course, this was before the days of comparative fault, but after the jury had returned its verdict in that case, the bailiff brought into the courtroom, while the judge still had the lawyers there talking about some issues, brought into the courtroom some papers left by the jury in the jury room, and the bailiff told Judge Davis that the jury had left these papers, and Judge Davis looked at those papers, and he said, this jury has attempted to compare the fault of these defendants, because they had attributed 60% of the fault, had 60% or $60,000 attributed to Coal Creek Mining and Manufacturing Company, and $40,000 attributed to my client, Regal Corporation. And so we had the earliest attempt that I've known about to use comparative fault, and we asked Judge Davis to set aside the verdict based on that ground. The verdict that the jury reported simply said they found for the plaintiff and awarded the plaintiff $100,000 against Regal Corporation and Coal Creek Mining and Manufacturing Company. And so in form, it was not a comparative fault verdict, but Judge Davis was right, I think, in that the jury had considered comparative fault. And we asked him by motion for new trial to set aside that verdict, but he would not do so. He did not do so. But as I indicated, we appealed the case to the Court of Appeals, and on other grounds, not that ground, on other grounds, the Court of Appeals reversed the case. And so it's a very notable lawsuit. And from there, I began working with Mr. Robert McConnell, who was the senior partner at Francis McConnell, and he represented the City Service Company, which was then the operator of the mining operations at Copper Hill, Tennessee, and I began to try all of the labor arbitration disputes that were generated out of the differences between the city service company, operator of the mines, and the iron workers who represented in their union activities the employees of the copper company. And so I took on a wide range of legal issues of all kinds and enjoyed all of those. I think at one time I was proud to say that after having tried some 30 labor arbitration cases, I had not lost a one. I think that record changed at some point in time, but in any event, I enjoyed that work very much too.
You not only were doing that, but you were also drawing wills and contracts for people, were you not?
Yes, and I began to try construction cases. Construction litigation was not widely prevalent in this area at that time, but I began to represent contractors, and designers, and architects, engineers, and disputes growing out of construction projects, and eventually developed a substantial practice in the field of construction litigation. And of course, all of this was also done in connection with a lot of work that I did in the products liability field. In 1967, the state Supreme Court adopted the theory of strict liability in torts as espoused by Rule 402A of the Restatement of Torts Second. And so and that was in a case styled Olney versus Beeman Bodley Company. The Supreme Court said, we're going to adopt this new California theory called strict liability in tort. And boy, that generated lawsuits from every corner of the globe. And I began to try those products liability cases and developed a considerable practice in the area of products liability. And it was a great time for trial lawyers in Tennessee. Litigants, both plaintiffs and defendants, were intrigued by products liability litigation. Litigants were willing to advance some very interesting and novel theories, and defendants were very zealous of the products that they were designing and selling, and were willing to aggressively defend those suits. And they were willing to spend the capital that was necessary to prepare those suits, because most of them involved the employment of experts. And so the use of experts in that kind of litigation and other cases began to increase substantially in Tennessee. And it was a great time for trial lawyers, because serious issues of great importance, were being advanced, and they were being advanced with novel and new theories, and it gave lawyers that were handling those cases an opportunity to be very creative. And it was a most interesting time. And I learned about products of all sorts that I would never have known about had it not been for strict liability and tort.
Also, weren't you for a number of years a member of the Board of Law Examiners?
I was. For about 10 years, I served on the Board of Bar Examiners and enjoyed that work, although it was quite tedious a couple of times a year, particularly in July when the July exam was given. Required a lot of work to grade all of those bar papers, but it was a good experience.
In 1990, you were elected to the circuit judge position formerly held by Judge Haynes here in Knoxville. And you remained there until December of 1913, as I recall. I mean 2013.
2013, correct.
Would you give us some of your observations about changing your role from one side of the courtroom to the other, and also the changes you saw during that period
Yes.
of time?
You know, that decision to leave the private practice and go on the bench was not made on my part without some agony. I had loved the practice of law and enjoyed trying cases and tried some very, very serious litigation. And I've often said that I was blessed by living through the best years of the American judicial experiment. But in 1986, I was fortunate to have been inducted in the American College of Trial Lawyers. And I sort of looked upon that as the pinnacle of my success as a trial lawyer. And I began to think that maybe there was something else that I would like to do to accomplish in my life. I had been a law teacher for a short period of time, and I'd been a trial lawyer for a good period of my life. And typically, I suppose, three things that lawyers generally do or did at that time when they graduated from law school was either teach or practice or go on the bench. And of course, there are a number of other careers lawyers can pursue. But anyway, I thought that perhaps it might be interesting to try to serve some time on the bench as sort of the consummation of my legal career. And so I decided that I would run for the circuit court job that Judge James M. Haynes was then occupying. At about the time I began this campaign, he publicly announced that he was not going to run for re-election. He had been on the bench, I think, about 36 years at that time, and was then the longest-serving circuit judge in the state of Tennessee. Longest-serving judge of any kind, I believe. But in any event, I began a campaign for that office, and political activities of sorts was not something entirely new to me. I'd never run for a true political office before, but I think I mentioned earlier I'd run in a contested race in high school for the presidency of the student council. I was the president of my class in college at LMU every year that I was there, all 4 years. And so I sort of thought that running a political campaign might include a measure of pleasure or some fun, and it did. And I got out and began campaigning, attending the meetings of various organizations, and meeting people throughout Knox County. And as the campaign heightened, I even got out and knocked on some doors in various communities and was successful in winning that election in 1990 and was sworn in and began work on September the 1st, 1990 as a circuit judge. Initially, the work did not seem much different than what I'd done as a trial lawyer. It was just on the other side of the bench, performing a little different function, but I felt very comfortable in taking on the role of a judge in those kinds of cases, particularly that I'd tried time and again when I was a trial lawyer. But you know, a lot of changes came during the period that I was on the bench. In 1992, after I'd been there just barely 2 years, our state Supreme Court decided to adopt the theory of comparative fault. And so we had to rethink how we tried cases and rethink how we charged juries, and it was an interesting and challenging time. At that same during that same year, the Supreme Court of our state also clarified the role and recovery of punitive damages in the Hodges versus Tooth opinion. And so we began to see new theories and new approaches to the trial of cases, and it made the job more interesting. As time marched on, there were other changes that were very significant. The legislature became more active in dealing with litigation problems and rights and remedies in a number of situations. During that period of time, the legislature passed a Uniform Arbitration Act, and arbitration became increasingly popular. And with it, then in 1995, after the Supreme Court had approved the concept of mediation, mediation simply exploded. And of course, the result of that was to decrease the number of cases that were actually tried, but I think it actually increased the number of cases that were filed, so that as a circuit judge, I was required to deal more with the preparation and preliminary issues, discovery, and the use of motions, particularly Rule 56 motions for summary judgment, increased exponentially. And so we didn't try as many cases, but we probably did more work. The use of Rule 56 motions for summary judgment became, almost in every case, somewhere along the line, you would have to deal with a Rule 56 motion. And the Supreme Court began to realize that they needed to tighten up the process a bit, or make sure that the way Rule 56 motions were decided did not diminish the right to trial by jury. And so we had new opinions that dealt with all of that, and frankly caused considerable legal controversy in the state. Many lawyers were of the opinion that the use of Rule 56 motions was invading the right to trial by jury. By the same token, many lawyers thought that the whole purpose of Rule 56 was frustrated if we didn't deal with those motions as we had done for several years prior to that. So the work actually increased in that respect. But it was a most interesting time for lawyers and for judges.
Do you have any estimate of how many cases you tried during your time on the bench?
You know, of my own personal knowledge, I really don't. Judge Workman, when I retired, I think looked back at the records and reported to me, and I think reported in some comment that he made publicly at that time, that I had concluded about 16,000 cases during that period of time. I never bothered to look at that. I was never particularly enamored with numbers. I was always more concerned about the right results, but I'm not criticizing anyone who looks at those things. I think they are important, but I think about 16,000 cases.
And you retired at the end of 2013.
Yes.
Ask you, you've been a law student, a law professor, a practicing lawyer, and a judge during your career, long and distinguished career. Would you state a preference for any of those, or did they occur at the right time in your life?
I think that they occurred at the right time. I'm frequently asked, have been, which I liked best, and I've often said, well, it depends on the time of my life you're talking about. I don't think that I would have been happy to have gone on the bench much earlier in my career than I did, and And I really, the years that I practiced, I enjoyed practicing law, and I really don't think I would have wanted to do anything else at that time. And although it sort of happened without any real serious effort on my part, I think that I would have never been happy had I not taken a shot at teaching the law. And so all of this is, I've just been most fortunate. All of it's sort of worked out in its own time and at the proper time. And I sometimes have thought that if I had it to do over, I would have tried to go on the bench a little earlier. And yet, I had the opportunity to serve, 22, a little better than 22 years, and that's a good long while. And so I think it all happened about the right time, and I liked it when it happened. I wouldn't want it any other way. I've just been tremendously blessed by, as I frequently said, doing whatever I wanted to do when I wanted to do it. So it was all very timely.
Finally, you have done other things other than the law. I know you have a lovely family. You've been active in your church, and you have quite a sporting life. I guess we ought to touch a moment on those aspects of your life too.
Well, I do have a lovely family, a great family. My wife is a retired secretary from the county school systems, and my daughter is a nurse practitioner, and she has two lovely grandchildren. My son-in-law teaches in elementary school, and is very committed to his work there. And so I have a great family, and my extended family is wonderful supporters and helpful in getting along with the things of life. I have enjoyed an active sporting life. I always felt like I had to have something that was a diversion, something to help me get away from the work that I was doing. And of course, in my earlier years, as I mentioned, I engaged in a lot of hunting and fishing. Fortunately, after I came to Francis McConnell Seymour, I found a dear friend and a companion that loved those activities in E. Bruce Foster Sr. And he and I engaged in fly fishing during the warm months of the year, and in the winter and cold months we engaged in a lot of hunting, particularly shooting doves, and we just hunted and fished like there was no tomorrow. If we had a spare moment that we could get away from the practice of law, activity that we both loved, we spent it in the outdoors pursuing fish and game. And then after Mr. Foster passed away, I became interested in playing tennis, and my wife became interested in playing tennis also, and we pursued tennis and enjoyed tennis together for a long time. And then after I'd become about 50 years old and began to experience a little bit of physical problems with playing tennis on hard tennis courts, I took up golf, and I've sort of played golf during these last few years like there was no tomorrow. And so I've always had to have something that sort of diverted my mind from the activities of work and the normal stresses that come from meeting deadlines and dealing with people who have conflicts in their life. And so it's been a very interesting life that I've lived in that regard. Several years ago, when Mr. Foster and I were fishing in the Little Tennessee River, which was later inundated by the Tellico Dam built by the Tennessee Valley Authority, the Tennessee Wildlife Authority, as it was called then, wanted to make a video film of fishing in the Little Tennessee River, and they chose me to do that. And so one of the real joys of my life is the video that they made of that activity, and they chose a still shot out of all of that to put on the face or the cover of the Tennessee Conservationist, the house organ or magazine published by the Tennessee Wildlife and Resources Agency. And so I have in my office at home a framed copy of the cover of that issue of the Tennessee Conversationist, which shows me landing a trout in the Little Tennessee River. And that's always been one of my prides and joys.
Thank you very much. We are out of time, but this could go on for quite a while.
Thank you.